Participants of the APJCJ, you are Karibu Sana, you are welcome to my class, online class, the doctrine of frustration and the law of contract, multiple choice questions that I am going to deal today. And anyone can unmute and read what I posted on the screen so that I am with you and you are with me, both traveling the same boat to reach to the destination. Okay, let me read it. The doctrine of frustration here is, which I want to make it out. And I allowed the another participants to Karibusana, welcome. And anyone can unmute and read what I posted on the screen. Anyone can unmute and read what I posted on the screen.
Okay, Prof.
Yeah, this is not the master class, this is the class of the JCJ, but anyway that you want to hear, you can hear also. Yes, let me read it. The doctrine of frustration, when the performance of the contract becomes impossible, the purpose which the parties have in mind is frustrated because of the supervening event. When the performance becomes impossible, the promisor is excused from the performance of the contract. This is known as the doctrine of frustration under the English law and is covered by the section 56 of the Indian Contract Act. And the host is Professor Dr. Mohammed Saheb, South Tanzania. And without wasting the time, let me go to my class. And the class is Andhra Pradesh Junior Civil Judge 2023 screening test to be held on 7th January 2023. The law of the contract MCQ. Participants, are you there? Say yes. So let me read the first question. The court of the appeal held the essential element of a contract were all present, including an offer, acceptance, consideration, and an intention to create the legal relations. And this was observed in the case of option A, Ramsay Gate, Victoria Hotel versus Montefiore. And the option B is Harvey versus Facey. Option C is Feldhaus versus Bindley. And the option D is Carlyle versus Carbolic Smoke Balls Company. Anyone can unmute and say that which is the right answer among the one A, B, C, D for the first question. Shoot, even though there is no negative marks. Quick. Participants, anyone can unmute and say which is the right answer. Monica, unmute and say which is the right answer for the first question. You unmute. You did not unmute, Monica. You unmute the microphone and yes, now you unmuted it. Now give the answer. Give me the answer for the first question. Option A or B or C or D?
Option B, sir.
Say loudly.
Option B, sir.
Read. I said read.
Harvey versus Facey.
Say loudly. Harvey versus Facey. Answer is wrong. Second option.
D, sir.
It is the D, Carlyle versus Carbolic Smoke Ball Company Limited. Do you know the facts of the case?
Yes, sir.
Do you know or you don't know? Say yes or no answer. Give me the answer in yes or no.
No, sir.
The facts of the Carlyle versus Carbolic Smoke Ball Company is they advertise in the newspaper that whoever uses the carbolic balls and their influenza will be cured within 2 weeks or some specific time is there, and they deposited at least 100 pounds in the Imperial Bank, and that give the sense that they do have intention to create the legal relationship there, and hence it is the contract, though it is a unilateral contract, one side contract, but it is a valid contract that is observed in the case of the Carlin versus Carbolic Smoke Ball Company case law. Is it clear?
Yes, sir.
Good. The second question. The 1999
Answer is
case
correct,
of
sir.
Dash was the foundation for the contract law as it gave birth to the purpose behind the creation of the legal reaction theory in contract law. That is decided in the case of option A, Ramsay Gate Victoria Hotel versus Montefiore, B, Harvey versus Tracy, C, Balfour versus Balfour, D, Feldhaus versus Bindley. Among the four, which is the right answer? The case law. Speak loudly.
Option C, sir.
When you are given the option C, Balfour versus Balfour, you have to say in that manner. So the right answer for this question is option C, Balfour versus Balfour is the right answer. Shall I proceed? Say yes.
Yes, sir.
Good. Now third question. What are the essential for a valid contract among the following? Number 1, offer. Number 2, acceptance of the offer. Number 3, parties must be competent to enter into a contract. 4, there must be a consideration that is to be lawful in fact. And the options are A, 1, B option 1 plus 2, C option 1 plus 2 plus 3, D option 1 plus 2 plus 3 plus 4. Which is the right answer?
Sir. Option D, sir.
I told you, no, whenever you're giving the answer, you should say option D, 1 plus 2 plus 3 plus 4. Repeat.
Yes, sir. Yes, sir.
I say repeat. When I say repeat, answer is option D, 1 plus 2 plus 3 plus 4. Answer is wrong. The right answer is, make the second attempt.
B, sir. Offer accepted.
I told you, you should not supposed to say in that manner. Answer B, 1 plus 2, you have to say.
Yes, sir.
Wrong. The right answer is option C, 1 plus 2 plus 3. The reason is, I have shown you the fourth you read. There must be a consideration that to be lawful in fact. It is not in fact. There must be a consideration that is to be lawful in nature. In nature is the right word. And hence, the fourth one is not correct answer. That is why D is eliminated and C is the right answer. That is 1 plus 2 plus 3. Is it clear?
Yes, sir.
Next, fourth question. Unmute and read the fourth question. Unmute and read the fourth question, which I highlighted on the screen. Proceed.
What are the essential for valid contract among the following? Free consent of the parties
Say loudly.
into a legal relationship. The contract enter into a must be certain. The contract must be a explanation declaration to a wide. Option. What are the
Option A, 1 plus 2 plus 3. Option B, 2 plus 3. Option C, 1 plus 2 plus 3 plus 4. Option D, 1 plus 4. The right option is should.
Option B. Option B. 2
I
plus
told
3.
you never give the answer in that manner.
2
You have to
plus
give the
3.
answer by reading the full.
Intention to enter into a legal
That is
relationship.
not the way of giving the answer. Option you took A, B, C, D. Read the which one is the right answer total.
Option B. 2 plus 3.
That is the right way of giving the answer. So the right answer is for the fourth question is B, that is 2 plus 3. What is the wrong in the first one?
Free consent, not
Consent.
assent.
Yes, that is the free consent of the party, not the assent of the party. What is the wrong in the fourth one?
A contract must
The
be
contract must be
There is a mistake or there is no mistake?
no mistake,
No mistake.
but it is not an essential.
There is a mistake is there on the fourth. Read the fourth above, read the feedback fourth. A contract must be expressly declared to be void, that is given the upper, but then the feedback, a contract must not be expressly declared to be void. I removed the not from there in the above. Is it clear?
yes, sir.
So here I wrote the assent, it should be the free consent, and the fourth one I wrote a contract must be expressly declared to be void, but it should be actually a contract must not be expressly declared to be void. Not I removed there. Hence, 1 and 4th is wrong, and the right one is B, that is 2 plus
2
3.
plus 3.
That is the way of reading, that is the way of giving the explanation. Now, fifth question. In the present case, the husband had signed an agreement with his wife for the pounds 40 per month in connection to their mortgage house. When the payment was made, the wife claimed the property to be hers. The Court of Appeal held that the agreement to be binding in nature as against the decision made in the Balfour's case. And which is the case law? Number A, option A, Balfour versus Balfour. B, Merit versus Merit. C, Leslie Limited versus Shield. D, Powell versus Lee. What is the right answer among the A, B, C, D options?
Option D. Powell versus Lee.
Wrong.
Option B, sir.
Option, I told you when you are giving the answer, you read the full. Repeat. I say repeat.
Merit versus merit, sir.
Or you say pass.
Merit versus merit.
Either you say pass on or you repeat.
Merit versus merit, sir.
You have to give the answer. The right answer for the fifth question is B, merit versus merit. That is the way of giving the answer. Is it clear?
Yes, sir.
Don't say B.
Yes, sir.
Because if you say B, I can hear it as a C. But if you say B, merit versus merit means I may be exactly the answer I can approach over there. Now next question, sixth question. England's Court of Appeal in the well-known case of Dash took into account whether a defendant who had promised to keep his offer till a certain day be bound by contractual obligations if he had revoked his promise and sold off his offer to a third party prior to the specified date. On which case law it is decided? Option A, Leslie Limited versus Shell. Option B, Paul versus Lee. Option C, Dixon versus Dodds. Option D, Phillips versus Brooks. See, this is the case. And these are the options. Should. Even though it is wrong, doesn't matter. There is no minus marks.
Option B, Paul versus Lee.
Wrong. Second option. Second option.
Option C, Dixon versus Dodds.
The right answer is C. Dixon versus Dodds is the right answer for the sixth question. Shall I proceed?
Yes, sir.
Good. Seventh question. In the present case dash, the injuries that were caused to the plaintiff from the defendant's defective products were claimed on the basis of the contract of sale between the parties to the case. While it was the plaintiff's friend who suffered the damage, the plaintiff did not. Hence, the plaintiff's claim could only be on the ground of negligence by the defendant. The issue before the court was whether the defendant owed a duty of care to the plaintiff or not. That is decided, number A, option Hadley versus Baxendale, option B, Donegal versus Stevenson, option C, Kedarnath versus Gori Mohammed, option D, Bhagwan Das Kedia versus Girdhar Lal and Company.
Option B, Donegal versus Stevenson.
It is the Donegal versus Stevenson case law where a party to the contract may not be there if any person who got suffered because of the product produced by the manufacturer had affected her. Do you know what is the facts of the case law? Donegal versus Stevenson? Anyone?
D, it may be Bhagwan Das Kedia versus
Already
Girdhar
answer I
Lal.
have given. The right answer is Donegal versus Stevenson.
Mhm.
What is the facts of the case law Donegal versus Stevenson? Anyone? If you know
No,
it, you
sir.
tell me. If you don't know it, you say pass on.
Pass on, sir.
It is the primary case law. Every person who has studied the law of tort is supposed to know this Donegal versus Stevenson case law because law of negligence is developed widely with this case law. Even though the victim is not the party to the contract, but still he can file a case because the element of the negligence happened over there. And it is a ginger beer case law. And a person has taken his fancy to offer her the ginger beer. When he poured in the first tumbler, he did not notice anything, but she consumed. Later on, second time, he poured in the tumbler and he found what he found in the tumbler? A lion.
Snail. Snail.
What type of the snail it is? Dressed snail, cooked snail, raw snail, rotten snail, decayed snail, putrid snail. You can use any word, decayed snail, rotten snail, or putrid snail. And she vomited and she suffered, and they filed a case against the manufacturer, and there is no break of the chain. There is a Latin terminology also there. There is no break of chain. Of course, the tort law is not there for your exam, hence we need not worry about that one. Shall I proceed?
Yes, sir.
Yes.
You can.
Appreciate. The eighth question. The Privy Council expressly barred any person below the age of 18 years to enter into a contract and take a major decisions in relation to the same. Thus, in the present case, where the plaintiff and the defendant had entered into a mortgage deed, the same was held to be void as the mortgage execution was carried out by a minor individual. That is held in the case of A. Raghava Charrier versus Srinivara. Option B, Mohari Bibi versus Dharmdas Ghosh. C, Jennings versus Rendall. D, Ryder versus Wombal.
Option B, Mohir Bibi versus Dharmadas Ghosh.
It is the Mohari Bibi versus Dharmadas Ghosh, where a minor entered into a contract by mortgaging the property and it is purely a contract. Hence, minor will not be held liable for the, what is the section says in the law of contract? Capacity to contract. Which section says? Supplementary question. Is it section 10 or 11? Which section says? Sir, we don't know. You check it, you will know it whether the 10 or 11, whichever is one is there. A minor to contract is void. Is it clear?
Section 11, wide contract.
Yes. So the ninth question. In 1799, a minor hired a horse for riding and injured it by excessive and improper riding. Held, M was not liable in tort for negligence, since all he did was contemplated by the contract, that is the riding. A minor may, however, be made liable in tort if is of kind not contemplated with the contract. So, which is the case law? A. D. Francisco versus Burnham, and B. Johnson versus Spy, and C. Jennings versus Rendall, and D. Bernard versus Huggies.
D. Bernard versus Huggies.
Wrong.
B. Jenny versus
C.
Spike.
Jennings versus Rundle.
The C is the right answer because he hired the horse, but in the case law they did not mention horse. They used another name. Can anyone tell me what is the another name? If you know it, you tell me. If you don't know it, you say pass on. Don't waste the time.
Pass on, sir.
They did not use the word horse. They used the word, I will write it here, M-A-R-E.
Mare.
Mare means?
Mare means a baby of horse.
No. M-A-R-E, mare means it is a female horse. The male horse is called a Hollywood actor name is there. And he played in the Rambo 1, Rambo 2, Rambo 3. Petrolina Chuma, this is the class of the JCJ. Anyway, if you are willing, you can hear. No matter. Yes, it is a stallion. The male one is called, male horse is called stallion. And the baby horse is called pony. P-O-N-Y, pony. But the male one is called colt, C-O-L-T, colt. And the female baby horse is called filly, F-I-L-L-Y. Is it clear?
Yes, sir.
Now, 10th question. There a minor hired a mare. It was expressly agreed that the mare will be used only for riding, not for jumping and larking. The mare was made to jump over a fence. She was impaled in it and killed. It was held that the minor was liable for the negligently killing the mare, as his act was totally independent of a contract made by him. In which case law it is decided? Option A, Bernard versus Huggies. Option B, D. Francisco versus Burnham. Option C, Johnson versus Spy. Option D, Phillips versus Brooks. Among the A, B, C, D, shoot, which is the right answer?
Option A, Bernard versus Huggies.
Option A is the right answer. And to those who are heard my lectures for the PG law set or All India Bar Examination 215 cohort, that the 15 cohort, 16 cohort or 17 cohort, I made the case law. What is that? A big classical case law which makes the distinction between a contract and a tort. And there I mentioned Jennings versus Randall is a law of contract purely, but when it comes to the matter of the Bernard versus Haggis, it is not the contract, because the contract says you should not supposed to use for the jumping and larking, and where the minor used the mare for the jumping and larking, and consequently the mare got impaled and finally died. That means a negligent element was occurred over there, and hence it is purely a law of tort. In the law of tort, a minor would be held liable, but in law of contract, a minor is not held liable. Is it clear?
Yes.
So that's why I made like that. 11th question. Completion of the contract and the price is usually required to discharge the contract. This is often in terms of the conditions precedent will be displayed. Trigger the requirement of the payment is complete. No completion, no fee. This rule was established in the dash is obviously capable of causing injustice. Option A, Cutter versus Powell. Option B, Francisco versus Burnham. Option C, Johnson versus Pye. Option D, Phillips versus Brooks. In which case law this was decided? Among the A, B, C, D.
Option D, Phillips
Cutter
versus
versus Powell.
Brooks.
It is option D, Phillips versus Brooks case law. It is happened. The above thing is made it no completion, no fee. The rule was established in dash is obviously capable of causing injustice. So that was the thing. And the next point is 12th. Which one is the correct one about the doctrine of frustration? Number 1. The doctrine of frustration basically talks about the impossibility of performance of the contract. Number 2, it means a contract can be executed because of an incident beyond the control of the parties. 3, the performance of such a contract becomes a frustrated, i.e., that is, it becomes a complicated, impossible, or even illegal. 4, the frustration of the contract can be due to any unforeseen, impossible events and events out of control of the parties. So these are the 4 statements I made it. Among the 4 statements based on the doctrine of constant frustration, option A 1, option B 1 plus 2 plus 3, option C 1 plus 3, option D 1 plus 3 plus 4. Now shoot which one is the appropriate answer.
Option A 1.
Option C, sir, 1 plus 3.
You are right, it is option 1 plus 3. What is wrong in the 2? Tell me. And what is wrong in the 4? You tell me.
It means a contract cannot be executed.
I appreciate. It means a contract cannot be executed because of an incident beyond the control of parties. So that is the actual cause. But what is the 4th one? Even 4th one is not right. Why it is not right? Again, it cannot be.
The frustration of contract can be due to any unforeseen impossible events and events of out of
Again,
control.
there also cannot.
Cannot, sir. Yes, sir.
Is it not?
Yes, sir.
So the answer to the question is 1 plus 3 is the right answer, because I removed the not and I used it. So a question can be asked in such a style also. And please note the point. They can ask from any angle. If I ask you, what is the section of the doctrine of frustration in the law of contract? Supplementary question. See, when you don't speak, you can mute it. Otherwise, I am getting the sound. When you speak it, you open it. When you don't speak it, you mute it. What is the section of the Indian Contract Act which says about doctrine of frustration? Sir, we are searching the smartphone. Is it?
Yes, sir.
56, sir.
See, I will show you here, if possible. Here, doctrine of frustration.
Section 56, sir.
See, here it is
Sir.
given. The
56.
doctrine of frustration under the Indian Contract Act. So it says a general rule is there. Section 56 of the Indian Contract Act says about the doctrine of frustration. And what are the conditions required to prove the frustration of a contract? Suppose the question asked in this way, then the answer should be the frustration of contract can be proved upon the fulfillment of the following conditions. Suppose if I change 1, 2, 3, 4, somewhere I can remove something, it's like I remove the knot here. For instance, I am giving the example. So you have to read under what grounds the doctrine of frustration will work or can be applied. When such a thing would be there, number one, the existence of a valid contract. The first and foremost, ab initio, the contract should be valid. Is it clear?
Yes, sir.
Good. Number two,
Yes.
yes, do you want to say anything? Anyone wants to say anything?
No, sir. Proceed, sir.
No, sir. No,
Okay,
no.
please, Petrolina Chuma, you can hear it. This is for the exam for the Indian students. I am giving a free classes to them for the junior civil judge examination, which is going to be held on 7th January 2023. So now, number one, the existence of a valid contract is one of the condition for making the frustration of the contract. Number two, I can remove sometime not here. Then I will ask it. But you have to be very much careful. The contract is not performed yet. Number three, the performance of the contract has become impossible. I can remove I am im and I can put possible also. So that we can be confused. Unless until you go thoroughly that yes, it is impossible is the right word. Then the fourth condition is the impossibility has occurred due to the event uncontrolled by the both the parties. See, that is not beyond their control. So what is the things not beyond the control of a human being? Anyone?
Earthquake, tsunamis.
What do you in what terminology you can say?
Act of God.
Act of God.
What is the act of God is a common name. Can you tell me its Latin terminology?
Force majeure.
Force
majeure.
See, there are two types are there. Act of God for the common law terminology is vis major. And the civil law terminology is force majeure. They don't pronounce force majeure. Force majeure, they will say. Because I don't know, because we don't know the pronunciation of the... It's a French word. In the French colony, they use that terminology. And in the one in a common way terminology is there are two types are there. One is the English terminology, another is British terminology, another is a American terminology. Natural disaster, or we can say natural catastrophe. Are you following me?
Yes, sir.
In the law of tort, we don't have law of tort. Otherwise, I would have to give the case law. Nichols versus Marshland, and that is a beautiful example for the act of God. And there is another example also there, but it is not act of God. Kallu Lal versus Hemachand. because I am the person who teaches law of tort, and hence I know the number of the case law. So now let us go to the another point is, if here they say destruction of a subject matter. It is one of the condition for the frustration, and the death of or incapacity of a party. That is also another condition, and the frustration by legal or governmental intervention. Suppose the waging war with another country, and where the contract you have with another country, at the time automatically enemy country becomes the enemy to you, then the frustration of contract will come out. So where the law is promulgated after the formation of a contract, making the performance impossible, then the contract becomes void. And another condition is the frustration of contract due to the change of circumstances. Like the situation occurs when there is no physical impossibility or performance of the contract, but due to the change in circumstances, the main reason for which the contract was formed is defeated. The changes circumstances dissolve the contract, and the parties are absolved from the performance of the contract. That means they are free from the contract, because the subject matter itself is impossible to exist in existence, and the parties are died. And if there is the intervention of the war is there, automatically the frustration of contract will come out. When you say the ship, you know the ship, SHIP ship. What is another terminology for the ship?
Vessel, sir.
Boat.
Vessel. There the ship is a masculine gender or a feminine gender?
Common gender, sir.
No.
Common
Ship is a
gender.
feminine gender.
Huh? Mhm.
If you see in the newspaper, if the ship, can you say the ship is drowned or ship is sunk?
Thank you, sir.
Sunk.
Why?
Drone.
Only animate thing will be drowned, and inanimate it will be sunk. Sink, sank, sunk. Is it clear?
But sir, there's a difference between ship, vessel, boat.
Yes, now you
There's a
tell
lot of
me.
difference between all these three. Ship is not a vessel, vessel is not a ship, neither ship, vessel is not a boat.
And now what is the criteria to divide it in the different category? What is the criteria to define a different category?
The ship is large one, boat is small one.
What about a vessel?
Medium size one.
Kante.
No, I mean, there's a reason for me. I didn't.
I will show you the
No.
vessel.
Boat is a thing which carry human beings,
Vessel
Container.
images I will show you.
and vessel is a thing which
Vessel generally it will carry the cargo.
That's what I'm saying. Which carries containers cargo.
This container, no? See, this is the vessel. But cruise is different again. Cruise,
Only cruise.
C-R-U-I-S-E, cruise, only passengers.
Cruise only passengers.
And it is for sightseeing. And you know that
And the ship.
Shah Rukh Khan's son, he was in the cruise at the time.
Aryan Khan.
Yes. So, vessel generally the containers it will carry it, cargo, and the ship it is for the both the things, passengers as well as the boat is the small one. Again, we can say burro also, barro.
But normally a ship, which means in defense language, a ship means it contains arms and ammunition.
Yes. And
That
barro
is-
images
that's-
also the burro, not burro.
So these are the basic difference.
See, this is the hole. Burro means one is the hole where these rabbits will hide. Then barro, I think it's a barro. This is the wheelbarrow. This is the wheelbarrow. B-A-R-R-O, barrow. Okay, now let us come to the noun, because anyway the situation has come, so I am giving this different explanation for you to know. And I would like to ask you the one case law. Can I give me the name of the case law? Can I give me the facts of the case law? Yes?
Facts
Tell
of
me
the
the
case
facts
law.
of the case.
A flip knife, still 5 minutes are there. A flip knife kept in the windows for sale. According to the act is concerned, the weapons are not supposed to be sold, and he was charged under the criminal charge of selling the abandoned, no, illegal, not illegal, is a what is prohibited weapons. What is the name of the case law? Flip knife case law in the contract is there. I will tell you in that contract it is not the sale but invitation to the sale. It is not the sale. It is a
Bumper half.
see here I have given the case law. Can anyone read the case law? The defendant
Sure, was
shopkeeper
displayed.
displayed in his shop window. Read. Read.
Defendant
The
shopkeeper
defendant
displays in his shop window a flick knife accompanied by a price
Ticket.
ticket
Ticket
displayed just behind it. He was charged with offering for sale a flick knife. Contrary to serial number 1.
Not section.
Okay.
Section 1 of the Restriction of the Offensive Weapons Act 1959. So now the issue is whether the display of knife constituted an offer for sale, in which case the defendant was guilty, or an invitation to treat or sale, in which case he was not. But here in this case law, keeping a tag to the flick knife for the displaying in the window, it is not amount to sale, it is the only invitation to treat.
Yes.
Court held that in accordance with the general principle of contract law, the display of the knife was not an offer of sale but merely an invitation to treat. And as such, the defendant had not offered the knife for sale within the meaning of section 1, subsection 1 of the Act. Although it was acknowledged that in an ordinary language a layman might consider the knife to be offered for sale. In legal terms, the position in the window was inviting the customers to offer to buy it. The statute must be construed in accordance with the legal meaning. So that's why we will say, why you have gone to the mall? No, window shopping. What is meant by window shopping? Just look at it, and if amount is there, then we think it out. And you know, generally in the window shopping, you don't enter into the shop. Am I right?
Yes.
You can see through the window only, and that's why the window shopping we can say. And never make the window shopping by keeping the money with you because you are tempted. Another case law, at any time it will stop. Can I tell the name of the case law? Can I tell the facts of the case law? Decide yourself.
Facts.
A person went to the tailor to stitch the three-piece suit, waistcoat, trouser, and coat, and he stitched it. And he filed for the case for the reimbursement of the amount. But he said the coat and waistcoat and other thing that you supplied is not the basic necessities for him, and hence you are not going to get any amount. Because he is a minor and he is a Cambridge student. At the time the age is more than 21 is major. Less than 21 is minor. What is the name of the case law? Iman versus Frasher Hash. I don't know what is that. Not hash. There is a case like Iman versus, let us see, let you type it. Three-piece case law. Three-piece suit case law where minor cannot be liable to pay.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।